All right, settle down, everyone. Welcome, KSLU students, to today's mandatory masterclass explainer. I am your professor, and right now we are rigorously dissecting a high-yield examination question that, mark my words, repeatedly appears on your constitutional law papers. A superficial, rambling answer is absolutely not going to cut it here. Our focus today is Question 15, Explain Original, Appellate, and Writ Jurisdiction of the Supreme Court and High Court. This is a foundational topic, and we're going to break down exactly how you must structure your response to secure top marks from your evaluators. So, keep your notebooks open, pay attention, and let us commence.
Here is your exact structural blueprint. We will cover 1. Introduction. 2. SC Original and Appellate Jurisdiction. 3. SC Writ Jurisdiction. 4. HC Jurisdiction. 5. SC versus HC Writ Comparison. And finally, 6. Case Laws and Conclusion. Meticulously replicate this exact synopsis as the introductory framework on the very first page of your answer script. For a 16-mark KSLU question, the evaluator expects a clear, logical roadmap before they even read a single argument. Writing this synopsis down demonstrates instant academic rigor, okay?
So, moving right into heading number 1, Introduction.
State your introduction heading clearly and boldly in your examination. Listen. Every high-scoring answer must begin with a strong constitutional premise. State that the Constitution of India establishes an independent judiciary. This includes the Supreme Court and High Courts. And then note that jurisdiction is broadly divided into 3 areas. 1. Original jurisdiction. 2. Appellate jurisdiction. And 3. Writ jurisdiction. Deliberately explain how this threefold division operates by listing these 3 jurisdictions in distinct bullet points on your exam page. Please do not merge them into one messy paragraph. Securing your initial marks relies heavily on visible, structured presentation.
Next up, Part I, Jurisdiction of the Supreme Court. I instruct the entire hall right now to use bold block letters for this Part I heading. You need to clearly signal this transition to the evaluator. Under Heading 2, Original Jurisdiction, Article 131. The Supreme Court has exclusive original jurisdiction in disputes between the center and state or states, state versus state, and crucially, these matters must involve legal rights. Class, underline Article 131 in your exam script. It is an absolute necessity. You must define original jurisdiction strictly as those disputes involving legal rights between federal entities. And the word exclusive here, that is paramount. It means literally no other court in the country can hear these federal disputes as a court of first instance. Do not forget to highlight that term.
All right, moving to Heading 3, Appellate Jurisdiction. The Supreme Court hears appeals from high courts under 3 distinct categories. A. Constitutional matters under Article 132, which are cases involving the interpretation of the Constitution. B. Civil matters under Article 133, which are civil cases of substantial importance. And C. Criminal matters under Article 134. Being appeals in serious criminal cases. You must subcategorize Article 132, 133, and 134 precisely as presented here. Detailing it this way demonstrates exhaustive statutory knowledge to your evaluator. It proves you thoroughly understand the specific constitutional avenues for appeal.
Now for Heading 4. This is the crucial power of the apex court. Writ jurisdiction, Article 32. The Supreme Court can issue writs for the enforcement of fundamental rights. The types of writs are Habeas Corpus, Mandamus, Prohibition, Certiorari, and Quo Warranto. Let's emphatically dissect this because it is vital. Article 32 is strictly for the enforcement of Part 3 fundamental rights. You cannot approach the Supreme Court under Article 32 for ordinary legal rights. When writing your answer, list the 5 specific writs clearly. Habeas Corpus to produce the body, Mandamus to command a public duty, Prohibition to prevent a lower court from exceeding its jurisdiction, Certiorari to quash an order, and Quo Warranto to ask by what authority one holds a public office.
Now switch your pens to black ink for this. Seriously, Article 32 is called the heart and soul of the Constitution by Dr. B.R. Ambedkar. Write this exact Dr. Ambedkar quote in your exam scripts and put it in proper quotation marks. This singular edition guarantees maximum evaluator appreciation, I assure you, because it shows a deep jurisprudential understanding of the framers' intent behind this writ jurisdiction.
Okay, let's transition to Part 2, Jurisdiction of High Courts.
This forms the second essential pillar of your long-form answer. Heading 5, Original Jurisdiction. High courts have original jurisdiction in civil and criminal matters, election petitions, and revenue matters in some cases. Heading 6, Appellate Jurisdiction. They hear appeals from subordinate courts in civil and criminal cases. Instruct yourselves to present these high court powers concisely. Notice how this differs from the Supreme Court, right? The High Court's original jurisdiction is not focused on federal center-state disputes, but rather on direct civil, criminal, and election matters at the state level. You need to make this distinction extremely evident in your writing.
Then we hit Heading 7, Writ Jurisdiction, Article 226. High courts can issue writs for the enforcement of fundamental rights and also other legal rights. Therefore, it is wider than the Supreme Court's writ jurisdiction. Let's dissect this crucial concept. Under Article 226, high courts enforce fundamental rights just like the Supreme Court, but they also have the power to enforce other legal rights. This makes the High Court's writ jurisdiction territorially narrower, sure, but conceptually much wider than Article 32. I urge you right now double underline the phrase wider than Supreme Court's writ jurisdiction on your paper.
Which brings us perfectly to Heading 8, the difference between Supreme Court and High Court writ jurisdiction.
Listen to me. A comparative analysis is the hallmark of a top-tier KSLU law student. Evaluators actively look for students who can synthesize and contrast constitutional provisions rather than simply listing them out like a laundry list. I want you to draw this exact comparative table in your answer script. Basis, Supreme Court, High Court. For Article 32 for the Supreme Court, 226 for the High Court. For scope, only fundamental rights for the Supreme Court, fundamental plus legal rights for the High Court. For nature, guaranteed remedy in the Supreme Court, but discretionary in the High Court. Use a rule or class. Provide this striking, unassailable visual breakdown. It saves the examiner time and immediately secures you high marks.
Now pay very close attention. We are at the case laws breakdown.
This is the absolute make-or-break section. Let me be very clear. Omitting landmark precedents in a constitutional law paper will instantly downgrade your score from a first-class mark to an average one. Landmark Case 1, State of West Bengal v. Union of India. Write this case citation in a separate boxed format, precisely in the center of your page. Do this to immediately capture the evaluator's attention for that 10-mark or 16-mark answer. The relevance here? Its original jurisdiction under Article 131. The issue involved a massive dispute between the state and the union, and the Supreme Court exercised its original jurisdiction. Now for the mandatory deep breakdown. The brief background of this case centers on a severe legislative clash where the state of West Bengal and the Union were at odds over sovereign territorial and resource rights. The final ratio decidendi, or the verdict of the court, established that when a true federal dispute arises involving a question of legal rights between a state entity and the central government, the Supreme Court is the absolute and exclusive arbiter. The absolute relevance of this case to Article 131 is that it practically demonstrates the Supreme Court functioning in its truest federal capacity, acting as the solitary umpire in India's quasi-federal structure. Explain exactly why this matters in your paper to prove your deep comprehension to the examiner.
All right, our second precedent, Landmark Case 2, L. Chandra Kumar v. Union of India. Again, I reiterate my previous instruction. Box this title clearly on your exam script using a contrasting pen color if permitted, or double underline the whole thing. The relevance here ties back to writ jurisdiction under Articles 32 and 226. The court held that judicial review under Articles 32 and 226 is part of the basic structure, and the High Courts and Supreme Court retain the power to issue writs. Let's really dissect the ratio decidendi here. The background involved legislative attempts to create administrative tribunals that effectively bypassed the jurisdiction of high courts. The Supreme Court decisively ruled that the power of judicial review vested in both the Supreme Court under Article 32 and the High Courts under Article 226 is a core, unalterable feature of the Constitution. That's the basic structure doctrine. The absolute relevance here is that Parliament cannot, even through a constitutional amendment, strip away the writ jurisdictions of these constitutional courts. Ensure you detail this basic structure doctrine in your answer to elevate your academic argument.
Finally, we reach the conclusion. Listen to me. Never submit an academic legal response abruptly. It is fundamentally incomplete. You must synthesize your final thoughts. The jurisdiction of the Supreme Court and High Courts ensures justice, protection of rights, and constitutional supremacy. Their powers maintain the rule of law and federal balance in India. Class, explain to your examiner how concluding with powerful, loaded terms like constitutional supremacy and federal balance ties your entire answer together. You aren't just listing articles here. You are explaining the very machinery that keeps Indian democracy alive.
Using these exact phrases leaves a lasting mark of academic excellence on the evaluator as they award your final score.
So, I leave you with one final provocative question. Have you rigorously memorized this structural blueprint to guarantee maximum marks on your KSLU constitutional law exam? Don't merely read the law, structure it, dissect it, and present it precisely as we've covered today. Internalize the strict explainer layout, use the designated headings, draw those comparative tables, and box your case laws. This right here is your ultimate tool for exam success. Class dismissed.